Thanks for clicking on the link and watching my video. I just want to talk very briefly about the different exams that are offered by the National Conference of Bar Examiners, the NCBE, on different state bar exams. I really had no idea until I was studying for the bar exam that each state exam would share certain portions with each other that are multi-state in scope. It wasn't until I started studying that I realized that my test had both the MBE and the MPT, and I didn't really know what that was. I didn't know where to look for the directions or the format or the overview. The website for the NCBE isn't the best, and if you go to your state bar exam website, they're usually pretty terrible. So I didn't even know what the NCBE was until later in the process, but they're actually kind of simple, very basic, and if you know what to study and the format, it will make it a lot easier for you. You can streamline what you're doing and have a better idea of what goals to set. I have a lot of good links on the website, and I've put a lot of the information together. I have a Excel document that shows individual states and the sections that are on your exam, so you can see what you'll need to study. And it also goes over all the subjects and the different topics that will be tested on each of these exams. Now, before we get into each individual one, it's worth talking about what multi-state law refers to. This is when you tell family and friends that you don't actually learn the law in law school. Well, these exams test you on that fake type of law. When you take torts or contracts and you're learning hypothetically what a certain tort is, or hypothetically what a contract is, but you're not talking about your individual state, that's what's going to be tested. These basic concepts. What is consideration? What is causation? Things of that nature. So the more general, the more basic, the more mainstream, the more majority, the more likely it's going to be considered multi-state law. And I know obviously different states have a minority approach or a majority approach or unique different takes on some of these concepts. The exam, however, is going to be testing the very broad general principle. If you think a question is confusing because your state does something very different than others, forget about that. Go with the much more generalized, common, the type of things that you'd be reading in your casebook when the cases are coming from many different states. But by and large, these exams are going to test things that are very general, very broad, and that shouldn't be too much of an issue. And one other thing about studying is, and again, these are on some of the documents I have on the website and links below, you'll be pretty surprised at the percentage of your state's bar exam that is actually multi-state. So much so that I find, for me, this is the case, and this is something that I'll recommend, is that you master the multi-state portions, the MBE, which is almost always 50% of the exam right there. And then the other 50% part of it oftentimes is either the MEE or the MPT. And then some states just test the uniform bar examination, so the whole thing's multi-state. But what I'm saying is, if you're from New York or, I don't know, some other, even Virginia, some other states, and if the MBE is half or almost half, a solid score on the MBE can practically get you a passing grade. Now remember, in most states, between 70, 80, 65, somewhere around that's the percentage of people who pass. So half of that exam, if you can nail it, you'll definitely be in the top half and earn a passing mark. A lot of times these state distinctions are very esoteric, very particular, and to sit there, memorize the distinctions for your state when you can be drilling for the MBE, I think is a waste of time, especially because even using multi-state law, you can still probably get a great score on the local portions. You'll just miss those state distinctions, but you'll still get a very good score that will go a long way. The most common multi-state exam, this is in almost 40 jurisdictions. Well, here, this is the document that I have a link below and you can get on the website. I have some good links where you can get some sample questions, general information, the full booklet that goes much more in depth about the exam. I just have the highlights here. These links are in this PDF. It's given on the Wednesday during the bar exam. So oftentimes your exam will either be on a Wednesday and a Thursday or a Tuesday and a Wednesday. It's 2 days for the most part. And that Wednesday is the MBE for everybody. That way half the nation doesn't take it a day early and then they'd have the answers. Everybody takes it on Wednesday. It's just a matter if your state portion is on Thursday or on Tuesday. So as I mentioned earlier, it's developed by the National Conference of Bar Examiners. There's no local law tested on the MBE, but it's given as part of the local bar exam in almost, it counts for half in almost 40 jurisdictions, and it's at least a significant portion in almost every jurisdiction. So I was wrong. It's not, if there are 40 jurisdictions where it's half or more, and then almost every single jurisdiction tests it for a significant portion of the exam. Here it is. Louisiana and Puerto Rico are the only two states, or two jurisdictions, I should say, that don't give it. So studying for the MBE is a must. And here, and I have this link here on this document where you can see this, your state and the weight that they give to the MBE on the local bar exam. The format is about 200, is 200 multiple choice questions that you'll take. The reason why I say about is because only 190 of them actually count for the exam. It's sort of like on the LSAT where you don't know that one of the sections is an experimental. Here, you don't know that 10 questions are experimental. Only 190 are scored. You'll get an actual score between 0 and 200 when it's scaled, but only 190 questions are counted to go into that raw score. You'll go in and you take a morning and an afternoon session. They're each 3 hours long and 100 questions. You can't go back. It's almost like taking two separate tests. So you have to sort of pace yourself twice. When you take the first section, it's good because it's 100 questions. You can easily map it out. Each hour you want to do about 33. And when you get to the end, you can tick off the questions that you want to go back to. But when that 3 hours expires, you need to have all 100 bubbled in and ready to hand them in. You cannot go back. And you use this a bubble sheet just like on the LSAT or other standardized exams. Now here I write that each question takes a little less than 2 minutes to complete on average. Now, if it was a shorter exam, a section on an LSAT, a lot of times you want to try to knock out each question in an even amount of time like that. But the MBE, you're going to see that some questions are extremely long and some questions are very short. Some questions you'll recognize because they ask the same type of material over and over again. The same, just like sort of on the, again, like the LSAT, there are certain questions you'll immediately recognize and you can answer those very quickly. With 200 questions, it's better to get a good answer, move on, than waste time double and triple checking. You will be happy that at the end of the exam that you have enough time to get through. You'll be very mad at yourself if at the end of a section the time is about to expire, you have 20 questions to go, and it wasn't worth going over those questions earlier in the exam unnecessarily. You want to get through all the questions. You want to get to a point where you can take a very good educated guess or a very solid answer, but don't go crazy. Be confident in yourself and move on. Yeah, here. When I took the MBE, I made a note of the hard questions and my initial answer for them. And I did this, sometimes I put a dot on the bubble sheet I thought was good. That way, if I do end up going, if I don't have time to go back, I'll just then fill in that dot for real Otherwise, I'll go back, come up with a better answer, may potentially erase the dot, and then put in a new answer. But I didn't. If I wasn't sure, I wouldn't circle all the way, because it's not necessarily easy to erase, and that might count. And it also signifies the ones to tell me that I want to go back to. So I thought that was a smart strategy for me. The question. So here's an example right here. You're given a prompt where it's like a mini fact pattern, essentially, and then you'll get a legal question to answer based on the multiple choice. So there's 4 potential answers. Just guessing, you have a 1 out of 4 chance. Really, the goal is to at least get it down to 2, go from 25% to 50%, and then obviously, if you know the answer and you're confident, go ahead and take that. Now, one thing here before I get to the scoring is that I find sometimes that law is, I personally do not think is a subject that is tested very well through multiple choice. There's always different nuances, and it's always very, very oftentimes impossible to fully explain something in just a sentence, like here, being totally clear. So, at least for me, I found that a lot of times it wasn't smart for me to read, then come up with an answer, and then look for the answer. I would read these and pick the one that I thought was the best, because these answers oftentimes weren't the answer that I had come up with in my head originally. And obviously you can't write anything in. You need to pick one of these. So I think a good strategy is to read through these and then pick the one that you think is the best out of those, as opposed to the one that as opposed to coming up with an answer that you think is right to start with and then going through these, because your answer might not be in here. The exam, as I mentioned before, is scored from 0 to 200. And it's scaled, so if you get a score of 150 on one exam, it might be scaled down to reflect the fact that it was easy compared to other exams, or it might be scaled up. Just again, like the LSAT, that way 170 means the same exact thing on every single exam. For the LSAT, the scores of the MBE all mean the same thing for each administration, or for every administration. There are 6 subjects, and there's a fixed number of questions for each subject. And for some of the subjects, when you look in the outlines, they'll even tell you the frequency of different broad topics within that subject. And in February 2015, I hope you're not looking that far in advance. Well, maybe I'll have to update this video when that comes out, but that's not for another year. At that point in time, the MBE will also include civil procedure, but it'll still only be 190 questions. They're just going to update the breakdown between the subjects. And here you go. Technically, torts and contracts are the most common, but you can see it's only by a margin of 2 questions. Everything is either 33 questions or 31 questions. There's torts, contracts, criminal law, and procedure, so it combines the 2. It's essentially criminal investigation, criminal law, search, seizure, and things like homicide and whatnot, evidence, real property, and constitutional law. The next exam is the Uniform Bar Examination. Now, this exam is unlike the MBE, which is a standardized test that is part of many different local bar exams. The Uniform Bar Examination is an examination itself. Some states, such as the ones here, I should say jurisdictions, Alaska, Arizona, Colorado, Idaho, Minnesota, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Utah, Washington, and Wyoming. If you're from one of those jurisdictions, watch this. If not, you can skip ahead. Your jurisdiction, instead of creating their own local bar exam and then having the MBE on the second day, they actually administer the Uniform Bar Examination as their bar examination, and then you take the MBE as well. The good news for you folks in these jurisdictions is that you generally do not have to bother learning any new state law. The reason why I say generally is because in some rare instances, again, this is in the Excel spreadsheet that I have on the website, in some rare instances, some of these jurisdictions do have a very small state portion or state essay. It's very, very small. I suppose you can learn the distinctions if you really want to nail it, but I don't see the benefit in that. I think just doing really well on the multi-state law can get you a passing grade quite easily. Although, do take that with a grain of salt, because some states might have a requirement where you need to pass every section individually in order to pass the whole exam, so you couldn't flop a state essay. The UBE breaks down like this. If the multi-state essay examination, which we'll talk about in a minute, is worth 30%, there are 2 MPT tasks. Those are worth 20%, so that's half the exam. And then the other half of the exam is the multi-state bar examination. So just for about everybody, the MBE is worth half of your exam, or close to that. So MBE is the most important thing there, except if you're in just the 2 jurisdictions that don't give the MBE. I think offhand that's Louisiana and Puerto Rico. If you live anywhere else, or I should say if you're taking the tests anywhere else, this is your make or break, is the MBE, to nail that. Individual jurisdictions, the one thing they do decide to do when it comes to the UBE is that they determine their own passing scores, and they grade the MEE and the MPT. The MBE, of course, is graded by the NCBE themselves. They mail that in and they grade that. States don't grade the MBE, but they can determine the passing score if they want. And again, as I said before, each jurisdiction may also require candidates to complete jurisdiction-specific portions that may involve local law. That's pretty rare, but that's worth double-checking. I have links to those pages that will show you that, will tell you that, and it's on the spreadsheet as well. The multi-state essay examination, there's links here. The booklet goes more in depth and has the subject outlines, but I have those as well on the website. It's administered on the Tuesday before the last Wednesday in February. So the day that you take the MEE would be before Wednesday, and on Wednesday you take the MBE. There are 6 30-minute questions, but individual jurisdictions, they can choose which of those questions that they want to put as part of their individual state's bar exam. But if you take the UBE, you're going to be doing 6 of these. But if a state does their own local bar exam, they can do up to 6 or they can do less. It's part of the bar exam in 31 jurisdictions, so this is quite common. They're listed right here. And again, this information is all on the website. I have charts, the spreadsheet. The subject matter, unfortunately, for the MEE is much more broad than the MBE. And there's no pre-established breakdown. You can be pulling your hair out learning conflict of laws and a business associations, and that's only a small portion, or it might not even be on there. And so these are all the subjects. I have full outlines of what will be tested, and you can find that information as well in the booklet. I have the link up here and on the website, and you can see exactly what these entail. Now, the format is that there is a prompt of about several paragraphs that give a broad overview, or give the facts, the basic facts of a certain legal situation. One example here, and this comes from a practice question, is that 2 people conspire to dump marbles at an intersection as part of a prank, and that prank turned deadly when a car drove through the intersection and lost control because of the marbles. The prompt, the facts, are then followed by specific legal questions. Within this example, the question might be whether they could be found guilty of involuntary manslaughter. You would draw upon your knowledge of criminal law and procedure. You might explain why or why not that statute would apply to them, and you might also bring up certain other things about how the evidence might have been illegally collected against them, and even though the statute technically would apply to their conduct, due to the fruit of the poisonous tree, the relevant evidence would be thrown out of court, and therefore they couldn't be found guilty, things of that nature. There are more examples of MEE questions in the information booklet. You can take a look there. A good rule of thumb is to structure your response by providing a very direct answer to the question asked. Remember, this is not your professor. These are graders who are going to be looking at a lot of things very mechanically, and they want to see a very direct answer to whatever question is specifically asked. That's not to say you can't add things that are brilliant, but make sure you directly provide an answer, because they're going to have a check mark. That's the first thing they're going to be looking for. And the way to do that, of course, very logically, to state and apply a relevant legal rule to those facts, as opposed to just making conclusions, because they're going to know what the rule is or the relevant law. They're going to want to check that off, and they're going to want to check off your analysis. And then that's where you can follow up by discussing any contingencies, missing facts, or other legal issues that it might affect the outcome. And as I said, this is where you can distinguish your response from other candidates, because they're going to have the checklist for the rule, for whether or not you knew the law and how you applied it. But then if you spot interesting other things, other arguments, contingencies, they're going to then give you, the check pluses there. And again, this is a good way of structuring it to identify legal issues raised by the hypothetical fact pattern. Separate the relevant and irrelevant facts in law. Something that they love to do is to give you a fact that has nothing to do with anything, and as a lawyer, you're going to say that that fact is irrelevant because it does not bear on the analysis, for whatever reason. Then to provide a logical analysis of all legal issues in a well-organized response. And finally, demonstrate an understanding of the legal principles. So you're identifying the issue, right? What do we need to figure out here? And what facts should I use to figure that out? What is the relevant law, and how does that apply through logical analysis? And through your discussion and through your writing, you're proving that you understand the legal principles. The scoring here, unfortunately, it's developed by individual jurisdictions. They do a terrible job at providing information, so I rarely, if ever, see a jurisdiction that really explains how they grade. Rule of thumb, you want to write, to aim to write the most logical, well-written, convincing, and thorough essay that you can, while using the legal writing skills that you learned in law school. You want to show that you're a great law school student. That's what everybody's going to be doing, that you can be a great lawyer. Now, finally, the multi-state performance test, the MPT. We have links here. Again, they're on the website. This is on the Tuesday before the last Wednesday in February and July. Like all of this, developed by the NCBE. If you're in a jurisdiction that administers the uniform bar examination, the MPT is 20% of the total bar exam score. The MPT is currently administered as part of the bar exam in about 40 jurisdictions, so this is pretty common. Chances are you're going to be taking this exam. Now, the thing here which makes this a bit different is that these are MPT items that have a file and a library. You're not actually being tested on your knowledge of the law, so to speak. Everything that, if whatever area, it wouldn't happen, but say for instance the question was on ocean law, you're going to have a file and library that give you the facts and give you the relevant statutes or pieces of different cases about the applicable ocean law. You don't need to know that, and you don't need to know the law ahead of time. This is testing how good of an attorney you are to answer a legal problem when the facts and the law are in front of you. Can you spot the issues? Can you learn and apply new law in a convincing and a good, legally, logically sound, concise manner? The file has the source documents, such as interview transcripts, depositions, pleadings, correspondence, contracts, etc. You need to determine what facts are relevant, which facts are important, which are reliable, because you can't base the entire case on maybe your client's own self-serving testimony, even though technically that it's evidence helpful. It's not necessarily totally reliable, and that might be a contingency that you talk about in your essay. And you also might talk about what missing facts might have been helpful if they were there or can be found. The library has legal authorities such as cases, statutes, regulations, or rules. A successful response will identify relevant legal issues from the file and use the authorities in the library to craft a solid legal analysis. You can take a look at these. The NCBE describes the task of the examinee, what you need to do to get a solid MPT score, separate relevant from irrelevant, analyze the library of authorities, apply relevant law to relevant facts, identify and resolve ethical dilemmas when present. Now, this might not necessarily even be in the question. This is something you need to identify. Remember, they want to test how well you can be a lawyer. Lawyers have to be ethical, and they have to be on the lookout for ethical dilemmas. Be a good writer, and overall you're completing the lawyering tasks that you're given within the time constraints. And something to point out is that not only are you given the law ahead of time, but you're not even operating really in the United States. Everything's fictitious here. Usually they call it Franklin, Olympia, something like that. And a federal circuit, this is fictitious. Of course, there's no 15th Circuit of the United States. And then here, if you look at the PDF, if you want, there's just a little more overview of what they're testing you, your ability to problem solve, your analysis, reasoning, communication, organization, and resolving ethical dilemmas. One thing here, I guess, is good to point out is to organize your essay as solidly as possible. It shouldn't be some rambling stream of consciousness. It should be a really well-written introduction, and then IRAC or crack method, whatever it is that you're most comfortable with, issue, rule, application, conclusion, and then divide it into sections. Again, the reality is that this isn't a professor or teaching assistant reading your essay. It's a bar exam grader who has probably read 100 already that day. You want to make it as easy as possible for them to understand what you're saying and give you a good score. You can find out more about the MPT, the links that I have, and there's practice exams. Since you can't really study because there's no law that they're testing, I say this: if you are a rock solid law school student, you're in a journal, you get good grades normally, you did well in legal writing, wrote a note, I wouldn't even really worry about this section in terms of practicing. If you have a little trouble, you can go through and do some of the practice MPTs just to get a feel for what you're dealing with, going over your response to see where your strengths and weaknesses were. I can read it, a friend, professor, somebody, to tweak your writing, tweak your legal reasoning, because to try to get every possible point on this section. If you know what, I know it stinks to write and read when you want to be studying, you want to be reading as you're preparing to go through this, but you know that it really is a place where if that's where your troubles lie, going over in a couple times, a couple of practices, and seeing where the spots are that you can improve, they might go a long way. That's that. Thanks a bunch. Check out the website, and good luck.